Welcome, everyone. My name is Sarah Ray from the Bloomfield Public Library. Thank you for joining us today for Estate Planning 101 with Attorney Bobzer. I'm going to turn this over to you.
Hi, everyone. Thanks for joining today. And thank you, Sarah. And this is going to be a topic that I think should be very relevant and important for many of you. Many of you should already have an estate plan, or you're thinking about updating your estate plan, or some of you may be saying, what is an estate plan? And that's what this presentation is really all about. My name is Lara Bonzer. I'm one of the partners at Sapega, Daly, Pope & Perry. We have offices around and in the Hartford area, and one of my focuses is estate planning. And so one of the most basic documents that you can have as part of a basic estate plan is a durable power of attorney. And a power of attorney is a document that you have during your lifetime, which states that someone else can step into your shoes to do financial dealings, business dealings, things of that nature. And this is a document which generally goes into effect as soon as you sign it. And it's really for any situation where you can't do these things for yourself. So it doesn't mean that you have to be mentally incapacitated and unable to manage your affairs. It could be that you are at the hospital having hip replacement surgery and you're mentally fine, but you can't get to the bank. And so you want someone else to be able to do it for you. Often the powers of attorney are what are called durable, meaning that once you sign them, they continue to take effect when you are incapacitated, meaning again, when you no longer have the mental capabilities to manage your own affairs. And that's one of the nice parts about it, is that it has disability planning built into it. We often want you to name not only one person, but a successor or a backup person, someone else that would be able to step into your shoes if that first person could not do so. One of the most important reasons to have a durable power of attorney is because if at some point in your life you don't have this document and then you need help because you're not able to manage your own business and financial affairs anymore, then someone has to go to a probate court and petition a court to appoint someone to do this for you. It's called the conservator of your estate. And it's a step that you really don't want to have happen because the court may not appoint the person that you wish to see handle and make these decisions for you. They may pick somebody else in your family that you would not have chosen. They may also pick a third party, someone completely unrelated to you or someone you do not know who is appointed by the court to do that for you. You never wanted to get to that stage. And so it's important to have an updated, current, durable power of attorney. The state updated its laws back in 2016. They added a host of provisions that are important called hot powers that give your agent as much flexibility and comprehensive powers to help you. And it's really important that you have this document in place. The other lifetime document that's very important, of course, is your healthcare representative document and your living will. The healthcare representative is the person who, again, is allowed to communicate with your doctors and be able to make medical decisions for you if you are unable to do so. That could be that you've come in unconscious from a car accident and a surgical decision needs to be made. And again, you can't communicate with your doctor, so the doctor's going to speak to your healthcare representative. Or it could be that there's an end-of-life decision to be made, right? That's the living will component. And the only reasonable hope of your survival is being on a machine and being on life support. That's not what you wish. And therefore, the healthcare agent is authorized to be able to remove life support. It often should have provisions in it that relate to HIPAA, right? HIPAA being the federal law that allows someone to step in and receive your medical records. So you want to make sure that there's a HIPAA provision, someone being named under that document as well. And again, this is another document where if you don't have it during your lifetime, this is where, if you don't have the capacity to sign a new one, a probate court can be petitioned to have a conservator of your person appointed. And similarly, this could be a person that you know or a person you don't know. And that's why it's really, really important to take these matters into your own hands and always make sure that you have this lifetime document as well. the power of attorney and the healthcare directive are both lifetime documents, meaning that they extinguish upon your passing. They are no longer in effect. The third basic document that everyone needs is a will, right? A last will and testament. The last will and testament dictates not only who is responsible for gathering all of your assets and making sure they're distributed to the person you want, right? Or your beneficiaries, that's your executor, but it also dictates, again, how you wish your assets to pass when you are no longer here. Keep in mind that a will is very specific as to what assets it controls. So for instance, if you have a joint bank account with someone else, if you have an account that has a beneficiary designation on it, if you have an account that is held in a trust, those are not assets that will pass under your will. A will only controls assets that are solely owned in your name, that do not have a joint owner, that do not have a beneficiary. For instance, some of you may have real property, right? You own a home and you own it solely in your name. That is what is called a probate asset, meaning it's an asset that passes under your will. The state of Connecticut says if you don't have a will and you have a probate asset, we will dictate where those assets pass under the laws of intestacy. And that's the state of Connecticut saying this is who we believe your next closest kin are. And that may, again, not be in line with who you wish to receive your assets, who you wish to take what you have that you solely own upon your passing. So it's very important that you have a last will and testament as part of your basic estate plan. Wills are also important because they provide for unexpected consequences, or they provide for a child who's disabled, or a beneficiary who may have an addiction problem, or for minor grandchildren, right? We have ways of drafting these documents so that we provide for all those contingencies. Because if you want to give all to your children, and if that child predeceases you, it's going to go to your grandchildren. We don't want a 17-year-old to come into a lot of money with no oversight and go spend it on a Ferrari instead of college. We want to make sure that those funds are held in a protective trust for that grandchild's benefit until that grandchild reaches a particular age, at which time the money goes outright to him or her. So there's a lot of different ways that a will can benefit you based on your needs, based on your family dynamic, based on who your beneficiaries are. But the most important piece is to remember that you want to dictate your wishes under the state of Connecticut, right? You don't want the state to sit there and say, well, this is who we're going to give everything to, when that's not what you wish. An important piece of an estate plan is also making sure that your assets and your beneficiary designations are properly titled. What does that mean? It means that if you have a joint bank account with your son because you have him on there for convenience, you have him on there because he helps you do your banking sometimes, and it's just easier to have him be a name on that account. But you have 3 children, and your intention was always that everything should get split equally between your 3 children. It's really important to remember that under the law, that asset, that joint bank account, is not going to be transferred or passed under the will to all 3 kids, right? The joint ownership of an asset means if one owner passes away, it remains in the survivor's name. The survivor legally owns that account. So if you pass away, your son, who's the joint owner, is going to receive all that money. And while he may be the best son in the world, legally, he's not required to distribute it and split it 3 ways with his siblings. Same thing for any other beneficiary designation you might have on life insurance or a retirement account, or any other account that has a CD, for instance, a beneficiary on it. If you leave it all to one child because that child is the most financially savvy, or it just made sense to put the oldest on there, keep in mind that there's nothing legally requiring that child to share any of that money or split it with siblings if that was always your intention. Equally, it's very important that if you have assets or a beneficiary designation on an asset that's passing to a child who may be disabled or has an addiction problem, or again, a minor grandchild. Again, that money will go outright to that grandchild or that disabled person and maybe unwittingly be used in a way that you were not anticipating, right? That minor grandchild might give it all away and spend it on, again, bubble gum and a Ferrari, and the disabled child might lose benefits as a result of getting money outright because now they have too much in assets to qualify for the benefits they were receiving. So part of what I do when I meet with my families is that we sit down and we understand the dynamics, not only of what you have in assets, how they're titled, do you have probate assets? Do you have what we call non-probate assets, which are the assets, as I just discussed, that have a joint owner or a beneficiary designation? But we talk also about the family dynamic and understanding, is there anything we need to do to protect anybody in particular in the family? And then you have, again, the concept with estate planning. A popular one is a will versus a trust. And some of you may have heard this before. Some of you may have trusts at home. Some of you may say, yes, I've heard about a friend who has a trust. Do I need one? Do I need both? How does this work? And while the will, again, controls those probate assets, right, those solely owned assets, it can take a very long time, sometimes up to a year, before those assets wind up in the hands of the beneficiaries as you intended. A trust is essentially an empty pot. It's a document that says that you are the creator. And in the case of a revocable living trust, and we'll talk a little bit more about what that is, you are the trustee often of that trust as well. And essentially, you're filling that empty pot with assets. So you're retitling, for instance, your bank accounts or your CDs or your investment accounts, and you're retitling them into the name of your trust. So they're no longer in your individual name, they're in the name of your trust. But as a result, you as trustee continue to have access and control to all of these assets. We can also transfer real property into a trust. So you might now be taking a probate asset, your home that you own in Connecticut, and converting it to a non-probate asset, because you have the ability to now fund this trust with assets and avoid probate, right? Part of the benefit of a trust is what we call probate avoidance. The trust reads similarly to how a will reads, in that the trust says during your lifetime, you have access and control over all of these assets. You can also amend this revocable living trust. You can change it. You have free rights to do everything. But it does also, again, read like a will. So it'll say, when I'm no longer here, here's where all these assets go, right? It goes to my children, it goes to charities, it goes to nieces and nephews, whatever it is that you wish. And so many people like to use a living trust as an opportunity to avoid probate. The other benefit of a living trust versus a will is that when a will is admitted to a probate court, it is a public document. So anyone can go in there and say, I want to see Jane Doe's will because I want to see whether or not I was included. And that allows them to also, if you have a child that's estranged, if you have a beneficiary who you're giving a different percentage to than another one, gives them an opportunity to also see the will and say, you know what, I'm going to do something about this. I'm hiring a lawyer and I'm going to contest this will. A trust is a private document. It does not get filed with the probate court where it's public and anyone can get a copy of it. So as a result, it's not something that you have to worry during your lifetime as someone's going to see this one day and there's going to be a problem. It is a private document. Often when we have a trust, we still have a will. The will is generally a will that says, if I forgot to put something in my trust, please distribute it with the terms of my trust. And it's called a pour over will, essentially, pouring everything over into a trust. So again, why create a living trust? One is the probate avoidance. It becomes a much more streamlined process when you are no longer here to be able to have those assets passed down to beneficiaries. The trust also provides for incapacity planning, right? Disability planning, so that if you are not able to continue to manage the trust and the assets, you would be able to know that there's a successor trustee in place. There's someone else who can step into your shoes and help. Again, privacy, knowing that this is a private document so that you don't have to have it submitted to a probate court where anybody can look at it when you're no longer here and say, you know what, I think I should have received something and I didn't, I'm going to do something about it. So a living trust is a very, very popular tool that we use with families to be able to avoid probate and have some privacy. Another reason that people set up a living trust is they set up a trust because they have out-of-state real property. So you might have a home in Connecticut, but you may also have a home on the Cape. And when we have an out-of-state piece of property in our individual name, when we pass away, it can trigger something called an ancillary probate, meaning someone has to go to Massachusetts, hire a Massachusetts attorney, and then ultimately have that attorney probate that piece of property in Massachusetts. When you have a trust, we're able to transfer, again, set up a new deed, transferring the property into the revocable trust. And as a result, while there still may be an estate administration process, right, as in Connecticut, a more streamlined one, you still have a situation where it's much easier for those beneficiaries of the Massachusetts property to be able to get access faster to that house and whatever happens with it. The trustee has much more flexibility without waiting for the probate court to give its approval to jump through different hoops. So that's another reason that often a living trust is used. Again, a living trust is only as good as what's in it. And so that's why it's important to make sure that the trust is funded and funded appropriately. So again, real property, bank accounts, investment accounts, those are often very good vehicles to be transferred into a trust. When we're dealing with life insurance, when we're dealing with retirement accounts, those are not accounts that get transferred into the trust. That's when, again, we're using those beneficiary designations on those accounts to reflect what's going on in the trust and make sure that they match or make sure that they're flowing into the trust, but we are not retitling them. Retirement accounts in particular have to remain in your individual name, right? An IRA, individual retirement account. So they can't be transferred into the trust, but we can manipulate the designated beneficiary forms for those accounts to be able to flow and match the estate plan that's in the trust. So again, two strong arguments for funding and using a trust. Some of it, again, was the out-of-state property, right? Here's the cabin on the Cape. The other is you have a family who, again, may disagree. You have an estranged child. You're in a second marriage. You're worried about some kind of privacy issues. That's another big, big argument for why we want to make sure that you may be a good candidate for a living trust. Keep in mind, there are different types of trusts that do different types of things. So while we've been focusing on a revocable living trust, some living trusts have flexible estate tax provisions in them to avoid estate tax liability upon the first spouse to pass away. Some of them are asset protection trusts for long-term care planning and Medicaid planning and protecting assets in the case of someone's illness. Those are irrevocable trusts. Meaning that once you enter into them and you put assets into them, generally you can't revoke it, you can't change it. You can't even be trustee of those trusts in order for them to be able to have the asset protection you need. So there are many, many different types of trusts. And it's important that when you do meet with an attorney or the right lawyer for sure, that you're really sitting down with them and talking about what your objectives and goals are. Is it just making sure that everything passes without probate and no probate avoidance to your beneficiaries? Is it about asset protection in case of the need for Medicaid or a long-term care crisis? Is it that you have a taxable estate under the law and you're worried about what happens with estate taxes? It's really important that you use an attorney whose primary focus is on estate planning or elder law, depending on your needs. Because when you find an attorney who dabbles in a little bit of everything, you got to be careful to make sure that they know everything that they are talking about, because it's a complicated part of the law, and you want to make sure, because you work so hard for everything, that it's being handled appropriately. So the big takeaways from kind of my, my presentation is really that if you don't have an estate plan, you need one. If you have an estate plan, kind of like when you go to the doctor once a year, having a legal checkup every few years is often a good idea to make sure your documents are current under the law and to make sure they still meet your needs. And it's just something that should be top of mind. It's something that you should really act on, because once you become incapacitated, if you should, and hopefully not, you're going to have problems because you can't update these documents anymore, and you don't have the proper legal documents in place for anyone to help you. So with that said, I'm going to open it up to questions. I hope some of you have some good questions about estate planning, and I'm happy to answer any of them.